Everyone, Brighton Dejechi is my name. Thank you for watching, thank you for listening. Hope you're doing well. For today, the topic of emphasis, uh, it is from the contract of sales of goods. As always, the topic of today, it is Nemo non habet, or the Nemo rule. So, when you look at section 29 of Sales of Goods and Supply of Services Act, it talks about where the sale by a person, not the owner. So for it, it's specialized that where that person is not the true owner and does not sell under the authority or with the consent of the owner, so the buyer will acquire no better title over the same. So that is what the rule is saying. But you remember, where there is a general rule, there is also what we call an exception. So, before that, when you look at the case of Lindsay versus Canley, it provided the principle that the buyer cannot acquire good better title if there was, or if the seller does not own or does not have authority from the owner, so the buyer will never obtain a better title from that person. So that is the principle that was laid in the case of Lindsay versus Canley. So when we look at the exceptions of the general rule, one, when you look at section 33 clause 1, it gives the quota of quod, that if the good was sold by court order, it means that the buyer will obtain a better title from the court. So that is the exception. But again, if it is the power of the statute or authority, section 29b, so that person who buys will obtain a better title from the seller, however much the seller is not the owner of the good. And when we look at the law of agency, we know that the principle of the agent principal relationship works, so that an agent can transfer a better title to the buyer if the agent sells or sell a good to a buyer. That good will obtain a better title. So when you look at the case of Fox versus King, where Fox sold a car to the buyer, and in this essence he acted as an agent, and the buyer, being that for him he did know that the agent does not obtain the ownership, for him he obtained a better title from the agent. So this works where there is a relationship of the buyer, a relationship of the agent and the principal. So when you look at section 130 of the Act, provide that the seller under a voidable title. So for this, it deals only and only where the buyer bought without the knowledge of the defect from the seller. So this comes in like an example. I went into the bond of the car, I found there someone, and I buy. So when I go after obtaining that ownership better title, then the owner, the real owner, will not come to me that I have not obtained a better title, because for me, I didn't know the owner, I didn't know the defect, I didn't know that the person who is selling me the car is not the owner. So to prove that this element, that there must be no knowledge of a defect from the seller, that's what is laid in this case. When you look at section 32, To go back where I've where I've said that the seller under avoidable title, that is section 30. Then section 32, it talks about where a person who has sold goods continue or in possession of this good. So for this, it is like categorized in two essences, where we find that a buyer is containing a possession. I bought goods from somewhere, however much I have not finished paying, but if I sell to another person, that person will obtain a better title over the same. Another thing is the seller or a seller having a continuing possession, that he bought, like I bought things. This works vice versa. I bought things, but before finishing paying, I sell them to another person. So the person who bought then would have obtained a better title over the same. So we have another exception where the buyer purchases in a market offered. If I go in a market and I buy a book, and that market is authorized, it is known, it is a public place, then the true owner will not claim that I have bought things. The true owner will not claim for the things that I've bought. So that's how it works. Another exception we have estoppel. Estoppel. This is explained like what you do is the one that can stop you from denying a better title. And estoppel is classified in three. One, estoppel by words, estoppel by conduct, and estoppel by negligence. So estoppel by words, this means that what I speak, like a good example, if I say go and sell this car, once you sell, I cannot come out and claim that you don't own a possession to sell, you don't own authority to sell, because it's what I've said, and that person who have bought it will acquire what we call a better title from me. So when you look at estoppel by conduct, these are conduct that we show when we are buying and selling. So in this essence, we have the case of Welfred versus Kanga Limited. In this essence, the agent sold a car, but the principal claimed that the agent had no better title to transfer the title to the buyer. But in this essence, the conduct for me coming into the bond and seeing someone who will come to me, someone who is selling it, and really in the bond, and that person is acting as an agent, then it means I have acquired a better title from that person. So that is estoppel by conduct. Then when you look at the estoppel by negligence, this is where you find a good example is like when you left a stamp in your office, then someone comes in and use that stamp to sell or to buy something or to do something else, and that thing that I have done, like selling, then that person who have bought will acquire a better title from that person, but not the person must own a duty of care. If I own the office, that person who is using my stamp must be like my assistant personnel, my assistant. So in that essence, there must be a casual link that a duty of care must be proven to that person. So Thank you for watching. Thank you for listening. Brighton Tejechi is my name. Stay blessed. I salute you all.